I think this is one of the weakest constitutional bills. I think I have no doubt in my mind that we will succeed in the bill. Of course, I'm never presumptuous about court proceedings. Let me give you in 2 seconds, in 15 seconds, the principal heads of arguments. One, it turns civil service accountability to the political executive on its head. Two, it turns political executive accountability to the voters who elect that political executive on its head. Three, it decimates federalism. Four, it converts Delhi government to a cipher without a constitutional amendment. Without a constitutional amendment. You can do it with a constitutional amendment. Number five, it actually negates the very purpose created 30 years ago. And I want to ask a question, which I'll ask in Parliament also. Why is it that no political party of any political color, BJP, Congress, Third Front, wherever the political color is the same in center and state, NCT, or different in center and NCT, nobody has tried this for 30 years. No one. Why? Because you are trying to be a control freak Sarkar. You are not able to digest a defeat in the elections. Now today I'm not about Kejirwal, I'm not about NCT. It could be you tomorrow. It could be me tomorrow. It could be any federal structure which is the idea of giving power to the voters of Delhi. And therefore, the legal point is it violates the basic structure. All these principles come out of the basic structure.
Two questions, and some you've answered before. The Chief Justice, in his own judgment, which gave you and your client, in this case, relief, you said that he wasn't saying, hey, go ahead, Parliament, make a new law. He was saying, if you want to, go ahead and bring a constitutional amendment, that's your right. You're saying this is not a constitutional amendment, granted. But let's imagine a scenario, this bill goes through. One, what do you then go to the court? Because it's already been turned into law. That's the first question. Two, the court itself did not stick to its guns. It passed it on to a larger bench. It could have said, no, we won't entertain this review petition.
No, let me explain to you one by one. Number one, the court has rightly put it before a constitution bench. We only wanted expedition, so we said you may consider that you can do it without a constitution bench. But they had equally good, and we agreed afterwards. Afterwards, we agreed let it be constitution bench. We are expecting the constitution bench to be there by the end of the month, hopefully, after the 370 hearings, etc. over. Number two, in a sense, the constitution bench will give very much greater weight to whatever judgment comes. If the Delhi status is to be clarified, it should perhaps be, in all fairness, by a constitution bench. Number three, the real question you're asking, which you've not so directly asked, which I'll formulate for you and then answer, is that there is a passage in the judgment which I succeeded in, saying that Delhi being a special status, Parliament can pass laws for it. Yes. Absolutely correct. Yes. But they don't tell you the next sentence. Parliament can pass laws for NCT, even regarding List 2, but those laws under Article 239AA7 have to be for reinforcing, supplementing, assisting, ancillary provisions to reinforce the governance of Delhi. Now, just see the way they have interpreted literally. Parliament can pass a law. Now, you know the entry List 2 has, let's say, 50 entries. Give me 1 minute, half a minute. List 2 has 50 entries. Assume 3 are out, 3 we are not talking about in Delhi. Those balance 47. Suppose Parliament passes 2 judgments which say in all the 47, the legislator is Home Ministry, not Delhi. That is, technically it is permitted because Parliament can pass laws. But can Parliament pass a law which makes that entire constitutional amendment 239 into one large zero? You cannot use the scalpel to kill. The scalpel is intended to heal and cure. So the idea of 239(7)(a) was to allow parliamentary intervention to reinforce the Delhi structure, not to decimate it. That's the point being missed out. And if you do that, you are violating the basic structure. Yes, you can change 239AA itself. Tomorrow
But if you say you assented to the fact that a constitutional bench is needed to settle this issue, then Chief Justice had that option when he first delivered the verdict, right? He upheld administrative powers for an elected Delhi government. He subsequently referred it to a constitutional bench. Now, if
no. Let me explain.
What? Okay.
We won a full thumping victory in the first matter, which was a challenge to a non-parliamentary law, an executive order, which said by an executive order that civil services control will lie largely with the central government. We challenged it, we won.
Yes.
In the course of that judgment, one para is written by the Honorable Chief Justice's judgment saying that there is a separate provision which allows parliamentary law for Delhi. He did not give an invitation to pass such law. Subsequent to that, this law is passed. So we have to challenge it again because this law was not there. That was an executive order. Now this law is passed in the guise of 239AA7 of the Constitution and that one para in the judgment. Not understanding that the 239AA97, I don't want to sound technical, your viewers can pick it up and see it in the Constitution, is to reinforce the constitutional structure of Delhi, which is a federal, a decentralized governance, not to abrogate it.